Let me bring up the next panel, which I'm participating on, so I will turn it over to Heidi.
Great.
Good morning, everybody. So for the first panel, we're talking about reforms that are targeted at software patents. And we're lucky to have here on the panel with us Mark Lemley, I think you all know, William H. Newcomb Professor of Law here at Stanford, Suzanne Michel, who is in charge of patent policy at Google, and Lee Van Pelt, who has done, I don't even know how many patent application prosecutions, opinion work, et cetera, for ages in the Valley here. So, and then me, I'm Heidi Keefe, and I'm a partner at Cooley, and I do mostly patent litigation, and lately, mostly software patent litigation. So you've got a bunch of different voices that all resound around the problems with software patents. So the first question I want to ask the panel, what makes a software patent different from any other patent? Why are we having a special panel just on software patents? Suzanne, why don't you start?
Well, I think it's important in this discussion to start out recognizing that there are different How's that? Got it? Okay, good. I guess they're taping. Okay. There are different kinds of software patents, right? Some cover complex encryption algorithms, and some cover performing escrow on a computer. And it's really this latter class of software patents where a lot of the angst is, where a lot of the problems are. And it's a good distinction to keep in mind. What's happened is that practical everyday functions are now performed in a computer, performed on the internet, and the functions like menu planning, looking up nutritional information, putting items into a shopping cart can all be done virtually, and these have all been patented. And that's obviously generating a lot of litigation, a lot of needless costs, and these are the kinds of patents that, because we have misapplied, the courts have misapplied the basic patentability criteria, we've gotten this vast swath of overbroad, abstract patents that really tax innovation. These patents over-reward easy ideas like, I know I want to do menu planning on a computer, right? And then tax the people who do the really hard work, who dig in, write the programs, take on the risk, get a product out to consumers. They are then taxed by these patents, which essentially no work has to be done to get these kinds of patents. And that's a vast, important distinction, say, from biotech, where you can't get a patent doing zero work. You really can get this one kind of patent, software patents, and then unleash it on the world.
Go ahead. You're going to say
Well, yeah, so I mean, this is an issue I really struggle with because I am constitutionally opposed to subject matter exclusions as a general rule. I don't believe that we should abolish software patents or carve out something special, and for various reasons, one of which is I think it's actually really hard in the modern world to define what a software patent is. Right? Suzanne talks about a couple of different things which have very different characteristics, right? An encryption technology and improvement in the way a computer system actually works is a different beast than, yeah, people have sold dog food over the internet in the past, but no one sold cat food over the internet, so I claim selling cat food over the internet. And both of those, in turn, are different from the hybrid gas-electric engine that controls the Toyota Prius, which is, after all, really, if you think about it, a software patent, because the only thing that's inventive about that, we had batteries, we had gas engines before, is the controller that switches between the power sources at an appropriate time. So I'm nervous about the idea that we're going to carve out a universe of things called software patents and say you can't patent these. That said, I also think we've got to recognize that for a complex of reasons, software patents are the ones doing the most harm in the system and probably doing the least good right now. that most of the time when people are complaining about the patent system, they are complaining ultimately about some of these software patents. And I think there are several reasons for that. Some of them are the ones Suzanne just articulated. We have arguably been too lax in granting patents, but some of them are a little, and some of them have to do with drafting. So we'll talk, I think, a little bit later on this panel about what I've said is the problem of functional claiming in software. We have let people get away with writing patent claims not to the program they wrote, not to the algorithm or the approach they took to solve a problem, but to the idea of solving the problem itself. With claims that say things like a computer programmed to achieve this result, or even more broad, a computer programmable to achieve this result, which is the subject of tens of thousands of software patent claims. So I think there are definitely kind of PTO practice and drafting issues, but I also think there are some more systemic problems, and it's harder to get a handle on those. We don't have a good vocabulary for understanding what the scope of a software patent claim is. If you write a chemical patent claim, any chemist can tell you what's inside the scope of that claim and what's outside the scope. That's not true in software. And I think probably most problematic, the rate of innovation in the software world is such that there's a major disconnect between the speed with which the patent office operates and the speed with which software operates. When Alexander Graham Bell got his very contested patent for the telephone in 1876, that patent issued 3 weeks after the application was filed. It was disputed. There was a case went to the U.S. Supreme Court, and indeed there's an entire volume of U.S. reports devoted to the question of whether that patent should have been granted. But 3 weeks after he filed his application, he had a patent. And that's in a world in which technology moved a lot more slowly than it does today. Right now, on average, to get a software patent takes you 4 years. And what that means is that every software patent, almost without exception, when it issues, is directed to obsolete technology. The technology that was the basis of the software patent has moved on, and that means either that we're going to litigate about old, past damages for old technologies once the patent issues, or it means we're going to try to take that software patent and mutate it to cover new generations of technology that are different than the thing I actually invented.
I will tell you it's almost always the latter.
Yes,
not
absolutely. Yeah, right. The former ones are less problematic,
that
but they're also
bother me. It's the other one.
they're also less lucrative, right? And so it's the people who come up and say, you know what, 15 years ago, I created a way to have sounds communicated between computers, and now I claim that what I own is voice over internet. I didn't call it voice over internet, and voice over internet looks fairly different than what I actually made 15 years ago, but you can kind of trace the language of the claims through to that. And I understand why patentees do that, right? Because they've got this problem that by the time the patent issues, their technology is obsolete. But it creates a real systemic disconnect between what we're doing as innovators and what the patent system ends up covering.
Well, and so I think one of the things that we've seen is right away, we're going to jump right into CLS Alice because 101 becomes the first question. So Lee, what about 101? What about how are we going to go forward? Are software patents patentable? Is the Supreme Court going to go that far? Are they going to do what Mark's afraid of?
Well, I think the problem with 101 is that it's been hard to make a sharp distinction. I think we've resorted to 101 because we've had a singular failure of 102 and 103 in the Patent Office to reject patents that should never have been issued. So if you go back to the mid-90s to the early 2000s, what happened was the Patent Office, it's true today, and it was even more true then, the Patent Office almost always rejects claims the prior art they use is issued patents. You know, the office actions that I see today, I'd say of the significant rejections, more than 80%, maybe as high as 90%, the examiner's using patents to reject patents, not the prior art and other literature. Now, if you looked at the corpus of patents in 1995, if in the semiconductor area, if it looked like the library at Alexandria, in the software area, the patent prior art looked like the box of paperbacks that someone might have left by the water cooler to trade. Okay? So what you had was prior art examiners not having the art to reject patents, and you had that combined with 103 before KSR. An examiner couldn't just say, look, people have been selling cloth by the yard at the general store and calculating the price since the gold rush, and now that you want to calculate the price of the computer over the internet, that's obvious. Examiner couldn't just say that before KSR. And so what happened in the mid-90s to the early 2000s, we created this large bolus of undigested material that emerged from the patent office. When we had the dot-com bust, companies failed. A lot of these patents ended up on the market and were acquired by patent trolls. And what we've been doing since the term of a patent is 20 years, as Mark noted, often the life of the patent far exceeds its actual technical usefulness. These patents have been creating large transaction costs in court. They've been difficult to invalidate because of the presumption of validity, and we've been working our way through that. 101 sort of seems like the easy way out. We don't have to think about prior art. We don't have to think about 102 or 103. But the beauty of 102 and 103 is it's able to filter out the bad and let through the good. And I think that 101 can sort of help the most egregious cases, but there's yeoman work to be done to get the patent office better prior art and to reject patents based on 102, 103. Because especially in the functional claiming area, if you have a broad functional claim, that should be the easiest patent for the examiner to get rid of with 102, 103, because it's so broad. There's all kinds of prior art it covers.
Suzanne, you shook your head no for a second there.
I agree with with all of that, in the sense that if we did a great job with 102, 103, and I would add in there 112, you probably, at the patent office at least, and this could be important for the administration and management of the examining corps, hardly ever need to get to 101. But I do want to give some defense to 101. I think it performs a very valuable function in the patent system, and that we can't just ignore it. And I would commend to your reading the government's brief in the CLS Bank case. The government really went in a direction that a lot of the other amici, I think, were a little nervous to go. Wish I had, in our brief, done a little more of what they did there, which was to say, look, the patent system is about furthering technology and about furthering science. And what Alice's patent is a business method patent. It's about escrow. And that's not what the patent system is about. That's not supposed to be protected, and they asked the court to give more guidance on what is an abstract idea and to clarify that legal relationships, business relationships are not what the patent system is about. I think that's a good way to go. I think it would improve our patent system quite a bit. And then what the Alice case is about is, once you're there, this tacking the words at the beginning of the claim, a computer system configured to suddenly create patentable subject matter. Clearly not, and I think, again, an important role for 101 to play in those kinds of claims, because the invention in those kinds of claims is not about technology. It's not about how the computer works or advancement in software technology. It's about advancement, or usually not advancement, but it's about that business method patent. And I think we do want that gateway. It's an important tool in litigation. It is it gets, as Lee said, to help get rid of the most egregious claims, but that's not a small number right now when you look at in the world of claims being litigated. It's a lot. Those kinds of claims are causing a lot of havoc, and I think we want to be able to use 101 as a tool to weed out those problems quickly in litigation.
Well, if you think about it, those are obviously going to be the claims that we're going to litigate because they're the broadest, squishiest ones that are subject to taking the square peg and shoving it into the round hole. But so with CLS, we have all this briefing, it's all in now, and everybody's had a chance to kind of digest it. The call of the question was incredibly broad. It wasn't, is this particular little tiny thing patentable? It was, is software patentable? So, Mark, what are they going to do with it?
Well, they're going to give us a clear answer that solves the problem entirely, and we won't have to litigate
And then we can all
anymore.
go home.
Right.
Yay, okay.
So seriously, I don't think that's what will happen for a couple of reasons, right? One is I don't think that's the way the Supreme Court has been approaching patent law more generally over the last 10 years. If you look at the difference between the Federal Circuit cases and the Supreme Court cases in patent law, time and again we see the Federal Circuit searching for a bright line rule, something that we can simply apply and solve the problem, and the Supreme Court saying, no, what we want is a multi-factor test, what we want is a kind of case-specific analysis that thinks about the various factors. So I think the Supreme Court is disinclined to come up with a bright line test. They've already said in Bilski versus Kapos 3 years ago, no, we're not going to give you a bright line test. I don't think they're going to do anything different in this case. I frankly think they don't want this case. They've done 3 patentable subject matter cases in the last 3 years. I don't think they have any interest in tackling this or trying to set out what the test ought to be.
So why did they take it?
Because the Federal Circuit split 5-5 on this critical issue en banc, and it's hard to, the cases are coming up every month, and it's hard to know what to do in a world in which the perception is, given the 5-5 split, when I find out who my panel will be, then I'll know whether or not I'm going to win. Whether or not that perception is accurate, I think the Supreme Court looked at that and said, no, we've got to have some kind of resolution. So, but I think there's a more fundamental reason we're not going to get a definitive answer from CLS Bank, and that is I don't think there is a definitive answer to be had here. I don't think there is a magic rule that can tell us what is an abstract idea and what is not. I do think there are 2 different approaches and one critical thing to watch for in the CLS Bank opinion. One approach to abstract idea, and one that I've advocated along with some other people in this room, is that it's really about overbreadth. It's really an O'Reilly versus Morse kind of case. Morse invented the telegraph, and the Supreme Court said, you can have a patent on your telegraph, and you can have a patent on telegraphs like it, but you can't have a patent on any means of using electricity to communicate information, which is what his Claim 8 covered, because that is too abstract. That covers an entire concept, however implemented. If the court takes that approach, I think 101 is going to be limited to the cases that really are trying to reach concepts rather than particular implementations. But if you look at the Supreme Court cases on 101 leading up to this case, which are primarily cases from the 70s and 80s, they have a different focus, and that focus is how much hardware is attached to the software and what's the significance of the hardware that's attached to the software. So the Gottschalk, Fluke, Gottschalk v. Benson, Parker versus Fluke, and Diamond versus Deere all start from some version of the proposition that software is just math, and math standing alone is unpatentable. What makes it patentable is attaching it to some real-world practical device, and the real-world practical device is the thing that imposes the limit. If the court takes that approach, I think they are almost certainly going to say, taking an idea that is otherwise unpatentable and just putting it in a general purpose computer, just attaching off-the-shelf computer technology does not turn it into a patentable invention. And if that's what they say, I think a lot of the software patents out there in litigation today are in serious trouble.
So it still gives me a chance to argue in court what a general purpose computer is or isn't.
Absolutely, but the notable thing about that approach and why I think it's not the right approach is we shouldn't care. Right? It's true there's a difference between writing a patent claim to my new computer program implemented in a computer and my new computer program implemented in an iMac. One of those is more specific than the other, but it's not more specific in a way that actually relates to the thing that's inventive about my computer program. My program's inventive, if it is, because of the software aspects of the thing, not because of the hardware substrate we happen to layer it on. And so, my concern is that the Supreme Court, when it looks at its old cases, is going to say, oh, you know what? Just putting it in a computer, putting math in a computer, putting software in a computer doesn't make it patentable. You need an inventive component in the hardware itself. You need a new computer, in effect. And I just think that's the wrong question.
So, Lee, what are you hoping comes out of CLS Alice in terms of helping your clients understand what you can get them patents on and what you can't?
Well, I agree with Mark that the sort of the O'Reilly v. Morse issue is probably the right answer. That there's something that's so overbroad that it becomes an abstract idea is what should not be patentable. Now, that can be a hard question to answer. If is Bitcoin is that an abstract idea, or is that tangible? Is it real? If someone writes some malware that takes money out of my account at Wells Fargo and transfers to them, is that abstract? That's difficult. But I think understanding it through the lens of O'Reilly v. Morse and saying, look, if it covers any possible way of doing something, it's too broad and it has a 101 problem.
Suzanne?
Yeah, I'm hoping the court will recognize that there can be real advancements in software technology and not approach this as all software is math. I didn't see the briefs really asking for broad statements that no software is patentable, and that would not make sense for a lot of reasons. But line drawing can be difficult, but that's no reason to not do it. And I, again, think there's a real role for 101 to play here in creating a patent system that's about innovation and not about taxing other people's work later with broad ideas because someone spent 10 hours writing a patent application, which is what we've got right now.
So I was going to say, just instead, I want to move us on to 112 because I think...
Can I say one thing on the 101 first, though?
Yeah.
Because I think maybe more significant practically than the question of how does CLS Bank come out and what's the substantive standard is what's the procedural standard. Patentable subject matter is a pure question of law, according to the Federal Circuit. The Supreme Court says it is a threshold test, but the Federal Circuit panel decision in Ultramershal versus Hulu says, well, it's rife with factual issues, and so you can't resolve it on a motion to dismiss, and you got to do claim construction first in most circumstances. That case is pending in Supreme Court review and probably being held for reconsideration after CLS Bank. But in some sense, as a practical matter, as a litigator, I think the resolution of that case is more important than the resolution of CLS Bank, right? Because if the answer is we can figure out on a motion to dismiss by looking at the claims and maybe construing one or two terms whether or not a claim is patentable, then we've solved a lot of the litigation abuse problems you're going to hear about later in the day, because we've got a cheap and easy way of quickly distinguishing between the patentable and the unpatentable ones. If the answer is we move 101 to the end, and you got to do your $5 million worth of discovery and all of your prior art workup, and then we add it as one more summary judgment motion at the end, it's just practically a lot less useful. You could think that's a good thing or a bad thing, right, depending on how your view of patentable subject matter, but it definitely changes the character of the litigation.
Yeah, and as a litigator, I completely agree. I mean, we've continued to file motions to dismiss based on 101, even in light of the law, and some judges have said this is a much better way to deal with this. Thank you very much. You're right. It doesn't look like there's anything patentable here. Let's move on. And I think that actually would help quite a bit. But one of the things we were talking about are bright lines, and one of the other bright lines that we could theoretically see in the future would be with regards to 112 and software patents. And I think, Mark, I'm going to start with you because I know this is an issue near and dear to your heart. So tell us a little bit about why we should be using 112 and vis-a-vis functional claiming to help us weed out some of the most egregious overbroad patents in software?
So I'm gonna dispute the characterization of weed out, and instead what I'm gonna call it is prune back. Right? Because I think the distinction between a patentable subject matter question and the means plus function claiming in section 112F is the distinction between saying this patent is overbroad and it's invalid and saying this patent is not actually covering every possible means of solving this problem in a computer. It's covering a narrower set of things. It is a narrower patent claim, and as a narrower patent claim, it is valid. So here, there's an article which you can see in the written materials that I've published called "Software Patents and the Return of Functional Claiming." What I argue basically is this. In the late 19th and early 20th century, after we invented the idea of the peripheral claim, people started writing their claims to cover broader and broader things, more and more abstracting away from the device, the invention they actually built. The U.S. Supreme Court finally had enough and said, you can't do that, right? You can't just say any tool, any machine for solving this problem that I've solved. Your patent claim ought to be limited to your machine and ones like it, and if it isn't, then it's invalid. Congress in 1952 adopted a compromise position. It said, if you write your claims in this broad functional language, if you claim not the machine you invented, but any machine or any way of solving this particular problem, of performing this function, we're going to read that claim differently than we read every other claim. We're going to read it as a signal that your invention is actually not everything in the claim, but the particular device or way in which you solve the problem, the machine you built, described in the specification and equivalence thereof. So if we call this means plus function claiming because the classic way in which you signal that you've done this thing is by using the words means for doing X. Right? If my claim includes the element means for processing data, if you take that literally under normal principles of claim construction, my brain is a means for processing data. This pen is a means for processing data. But what patent law does is it says we don't take that literally. We use that, the fact that I haven't given you structure, I've only given you the function that's being performed, as a signal that we ought to go read the patent and limit you to the structure that's actually in the patent. Now, software patents are overwhelmingly written today in functional language. There is no structural definition of the program that is written. The only structure that's in there is kind of a basic hardware structure, a computer. And the result is that we write patent claims that say things like a computer programmed to solve this problem or a computer programmable to solve this problem. And we wouldn't allow those kind of claims in any other area of technology. Imagine that I'd come up with a chemical that treated cancer, and I decided, well, I don't want to be limited just to the chemical that I've invented. There may be other treatments for this form of cancer. So I claim atoms configured to cure cancer. No way we'd allow that claim, right? But that's essentially what we allow in software. I think the right way to think about this is when you write a patent claim that says a computer programmed to achieve this result, a computer programmable to achieve this result, certainly, you have written a means plus function claim. You have not told me the software structure, the algorithm that actually performs that function. And what your claim ought to be limited to is the algorithm you actually disclose in the patent specification and equivalence thereof. That's what the statute says in section 112F. And if we do that, we solve a lot of the problem of overbreadth, of me saying, well, I now own shopping carts or voice over internet or whatever else because I've claimed a computer configured to perform this function. And we limit the patent claims to cover really just things that are done in the same basic way. That have a similar algorithm. And I think doing that not only gets us around the 101 problem, that claim isn't abstract anymore, but it also gets us around a lot of the problem of patent trolls over-claiming and trying to assert their patents against things that they didn't really invent.
So I've actually tried to do this, by the way, in litigations, and I've actually told courts this is what's going wrong and this is what's happening. And I've had judges say, yeah, but they didn't use the word means plus function. They get the breadth of it. They get everything that they're supposed to get. And that law doesn't apply. I even used Halliburton. I did all of your little steps. And the judge looked at me and said, not yet. Maybe when the Federal Circuit tells me to, or maybe when the Supreme Court does. But go ahead. Lee, you were going to say something.
I think Mark is absolutely right that this issue of realizing if something claims a function, whether it says means or not, and by the way, every method claim recites a set of steps, and 112 paragraph F actually says means or step. So, I think that just someone reading that part of the statute would help. But I think...
Not always easy to get the people that you need to read that statute to actually read that statute.
Exactly. I think there's one thing we need to be careful with the functional claiming, and that is we can actually cause some problems with examination, and this is something that absolutely needs to be addressed. The problem I'm talking about is what I call a cross-construction. Because 112 paragraph F requires you to look at the specification and perhaps narrow the claim based on that, it makes it harder, potentially, for examiners to reject claims based on prior art. And it creates the potential for the patentee to sort of thread the needle, to get a more narrow construction that the examiner's using because they're limiting the claim based on the spec, and then to go in court and sort of walk away from that and get a broader construction. This is a very real problem, and it will happen. We must respect entropy in the patent system. Entropy, one definition is if there are states a system will get into, it will get into all those states. Now I have a 2-year-old. I understand this definition of entropy because everywhere in the house that Elmo could be, Elmo has been found. I open my desk drawer and there's Elmo. I mean, it's just, so what will happen is you will see the situation where patents will actually, we need to avoid this functional claiming, making it easier to get patents through the patent office because the patent office has to read the claim as being more limited. And so the part of the law that really needs to be fixed is the sort of Allapot and Donaldson line of cases that says the patent examiner can't reject a means plus function claim just by finding prior art that does the function. That is very important. We're going to end up with patents getting through the patent office and then asserted more broadly, which is the worst problem of all.
So I think I disagree with that for a couple of reasons.
Really?
Suzanne gets to talk first.
All right, go ahead.
Yeah, Suzanne gets to talk first.
I will agree it's a problem to be sensitive to, and one way to deal with it is that the examiners need to really put on the record what kind of claim interpretation they're using so that the patentee can't backtrack later, right? And that is part of the training that they're getting is about putting this on the record. I will say right now our sense is that examiners, in fact, don't limit the claims according to the specification in that way and apply the broadest reasonable interpretation. And I don't see the PTO's current training materials on functional claiming is changing this and really getting examiners to do this yet, but then we'll see. I wanted to go back to the court situation a little bit also, though, and talk about this problem that Heidi's having, which I think is a really serious problem. We have outside counsel try to talk us out of treating claims as 112F claims that have this sort of language of computer configured to. It's say, the judge isn't going to do it. We might as well not even make that argument unless the words means is there. I think patent law is at its worst when it elevates form over substance, and this is an area of law where that has happened in the extreme. There is in the law a heavy presumption, quote unquote, that 112F does not apply unless the word means is there. The justification for this in the case law seems to be that the court is trying in a matter of claim interpretation to discern the intent of the applicant. The intent of the applicant is irrelevant It's a claim interpretation, so we don't need that presumption. The presumption, if it ever made any sense, may have made some sense in mechanical cases. It, again, makes no sense in software cases where you're talking, the computer is the means, the processor is the means. We don't need this presumption. And so the number one thing that has to happen is to recognize this presumption makes no sense in the software context.
That's absolutely right. If you functional language, regardless of whether you use the magic words, it's functional language.
Well, and look, I think that is a problem which I understand why district courts are reluctant to say, given the Federal Circuit has made this very strong presumption. But the word means never appears in the statute. There's certainly no presumption in the statute. The statute says if you wrote a claim to a function without the disclosure of structure, material, or acts in support thereof, it is a Section 112F claim. And the first time that one of these cases goes to the U.S. Supreme Court, which has never had a 112F case, they're going to look at that presumption and they're going to say, I don't see that presumption in the statute. Show me the structure in the claim. And if you can't show me the structure in the claim, it is a means plus function claim to which Section 112F applies.
That'll be fantastic. And I know my clients will be thrilled because I'll be able to tell them that I've got another hook for them. But as of right now, I'm trying. I'm out there trying with district courts all the time, and the district courts say, it's not bright enough for me, there's a means word or there's not, and so we're stuck in that limbo land.
I think that's right until some of those cases get appealed, right? So from a litigation strategy perspective, the answer is, you're going to have to lose in the district court in some of these issues, right, to take that issue up, and that's kind of the way of the world. But I think ultimately the court, maybe the Federal Circuit, but certainly the Supreme Court is going to look at this and say, no, that's not actually consistent with what the statute says. I do want to respond to Lee on the prosecution issue. So I am.
Sword comes out. Here we go.
Well, so the nose of wax problem for both sides in litigation is a substantial problem in all areas of patent, right? Every patent owner wants their patent claim to be narrow in the patent office and broad in litigation. Every accused infringer wants it to be broad for purposes of invalidating it and narrow for purposes of infringement. People are always trying to play this game. But I'm less worried about this here than I am in some other areas, in part because we have a rule in the Patent Office that says you give a claim its broadest reasonable construction. And that means, I think, either that the Patent Office is going to say, oh, it's not a means plus function claim, it includes all possible ways of doing this, or they're going to say, you know what, it's unreasonable even to think that this is anything other than a means plus function claim. And is there a risk that the courts are going to ignore the Patent Office if they say the latter thing? I suppose there is, right? But I don't think they should be ignoring it, right? I think if the examiner is willing to go on the record and say, this is a means plus function claim and that's why I'm allowing it, right? It's a travesty if the courts then say, you know what, we're going to ignore the Patent Office's construction.
They're not doing that, though. They're not giving us that clear guidance that this is. The examiners aren't giving us what everybody here has agreed would be great, which is the examiner says, this is the construction I used, here's how I got to it. The court's likely to say, thank you, my job just got easier.
That's a great file history where that happens, but it doesn't. I mean, you still see the notice of allowance and the reason for allowance being a paraphrase of Claim 1.
It's usually a direct quote. Nothing has, and then it's the quote, right?
Right. It's a paraphrase or a quote, a direct quote.
Or it's an examiner interview, but that's another issue.
The issue is, even if the Patent Office says, okay, this is 112 paragraph 6, what you are not going to get, where you have the opportunity for some very pliable wax to make a nose out of, is that, what's the Patent Office, what does the examiner consider to be the equivalence in the specification versus what can the equivalence be urged in litigation? There's an opportunity for a lot of mischief there. And I think, Mark, when you say the broadest reasonable construction, I think the broadest reasonable construction should be just simply limited to the function only, that the Patent Office should be able to reject a means plus function claim just by finding the function in the prior art. I think that's very important.
I disagree with that.
You don't think that's the
The
broadest
shaking
reason?
of the heads.
Well, so look, think about it from the applicant's point of view for a second, right? So let's say I actually wanted to write something that was means plus function claim, and I intend myself to be limited to this algorithm and equivalents thereof. Before In re Donaldson, the PTO could do exactly that. They could say, you know what, we've got other completely unrelated structures that perform the same function, and therefore you can't have a patent on the new one you've created. I don't think that's fair.
Well, I think the reason why that's not really a problem is because the patentee can always amend in the patent office. So they can amend and make the claim clearer that it's limited to a certain thing. And I don't think you can underestimate the ability of litigants to try to assert their patent more broadly than it was actually written. When you look at the Garmin case, it's a very interesting case, an IPR. You've actually got the board has said that has refused to take on the construction that the applicant has urged that in court. So the applicants urged a broader construction in court, and the patent office is saying, no, we're not going to interpret that broadly because we don't think it's reasonable. You actually have the possibility in that case where the patent office will issue the patent because of a narrow interpretation than the patentee is currently alleging in court. I mean, it can happen.
Look, Lee, you and I are on exactly the same page with respect to the incentives and abilities of litigants to overclaim their patents, right? The question is whether that's a reason for us kind of not to try to think about these things as narrower means plus function claims. That argument would work only if we thought that the patent office was going to not issue the claims anyway. And I don't think I believe that at all, right? So they're certainly issuing lots of these things in the world in which they were treating them not as means plus function claims. So the idea that, well, if they treat them as not means plus function claims, they're going to reject these claims and they'll never go out there, I think has failed as an empirical matter, which is why we've got tens of thousands of these patents of this form showing up in litigation. And so it's certainly a risk that litigants and courts ought to be worried about and guarding against, but I don't think it's a reason to say we ought to systematically treat the claim in the patent office as covering something that we don't in fact think it covers, right? As not being a means plus function claim when we think it is.
But I think one of the things that we can actually shift very nicely into here is, what do we do if it does get through? What if, for example, the examiner allowed the claim because he thought that it was means plus function, there was no other prior art out there? Is there a way to go back and say, but here's the prior art you were missing. Here's those textbooks that somebody said were sitting next to the door that nobody wanted to use. How do we do that? And I think IPR and CBM are kind of interesting ways that we're all finding right now to affect a reform of the system in its own way. So, Suzanne, why don't you talk first about what you think about both CBM and IPR as a way to help this issue?
And maybe explaining what those initials stand for the benefits of some of the
CBM
audience.
is a covered business method challenge to a patent, and IPR is inter partes review.
So, without getting into the specifics of the covered business method program, I'll start out more broadly and to say a lot of the discussion we're having right now is about the 101 problems and the Section 112 problems that patents that are commonly used in litigation that we all agree is, at least on this panel, fairly harmful to innovation, is a problem. And it would seem to be good public policy to allow faster, cheaper challenges on 101 and 112 grounds before the expert agency, and not to have to go to court to have those issues reconsidered, given that we've all acknowledged there are a lot of these kinds of problems out there. Right now, the only way to bring a 101 or 112 challenge to the patent office on a currently already issued patent is through the Covered Business Method program from the American Invents Act. And that program is limited to financial services patents. something that the banks asked for in the last round of legislation. The best public policy would be to allow these kinds of challenges on all patents. I have not heard a good intellectual justification for letting the Patent Office review patents under 102 and 103 in the Inter Partes Review Program, but not under 101 and 112, even though those are patentability criteria too. And so I think the debate we're having around legislation right now is, should we allow more of 101 and 112 challenges on some subclass of patents, business method patents, for instance, because they are often used in litigation right now?
And that raises a very interesting question because of a decision that came down just last week at the IPR. So in IPR, which is the Inter Partes Review, a challenger can go back to the Patent Office to try to invalidate a patent, but they're limited to using patents and printed publications. They can't raise 101 or 112 issues. And we had a case just last week where the Patent Office declared the review, went all the way through the trial and the hearing. After the trial and the hearing, the board issued a written order this week terminating the proceeding because they found that they couldn't give a definition to the words under 112, so they didn't know what prior art to apply. But because they had no authority to invalidate under 112, they simply terminated the proceedings and didn't get to the issue of whether or not the patent was invalid under prior art. So I think that kind of highlights...
I think that shows the folly of splitting the process, because when you split the process, so the outcome of that is that, and by the way, the court construed those claims.
Correct.
So the court said, we can construe them. There's no 112 issue. And on the other hand, the poor defendant, RIM, they paid their $30K to do the IPR and then went through the whole process. And they can't get it invalidated under 102 and 103 in the Patent Office because the Patent Office disagrees with the court about 112. So they've lost that ability. I think you've got to unify. When you separate the issues into different forums, you create the opportunity for entropy to get different answers in different ones that are inconsistent, and inconsistency can cross and just mess up the defendant.
Mark, what do you think about that decision that came down this week?
Well, I mean, I agree with Lee that it's it's quite perverse to say, well, this patent is so invalid we can't even tell what it means and therefore we can't invalidate it. But it is in fact one of the results of the limitation of the statute. And so, as a conceptual matter, the idea that we ought to unify the validity determination, I think, is right. Both to avoid these kinds of interplay problems, but also because, there's a risk from the patent owner's perspective of people taking too many bites at the apple, right? So that is, if the answer is I can bring an ex parte re-exam and an inter partes review and a covered business method review and assume a post-grant opposition and I could challenge it in court, the patent owner's getting hit with multiple challenges. We've imposed some limitations on that with in the statute, but as we go as we move towards a system in which the answer is I should get one place in which I could bring all of my arguments, the question as a practical matter for lawyers and clients is, where is that place? I'm not sure, right, even if CBM allows you to reach all of these things, I'm not sure it's CBM. I'm not sure that I would tell my company if they were facing a substantial damages award in an infringement lawsuit, don't argue validity in court, take it all to the patent office and trust them to do it. It may be that over time people will develop that trust. Certainly the patent office's track record to date on these new mechanisms suggests they're serious about invalidating claims. This is not the kind of rubber stamp that ex parte re-exam was 10 years ago, where it was the patent owner who went back to the patent office and said, please bless my claims before I go into litigation. but I'm still nervous about telling clients it's okay to give up your invalidity defense in court and take it to the administrative proceeding instead, unless those clients can't afford court. Right? Unless they really just can't afford the amount of money that it takes.
I disagree with that, actually. I mean, because I'm actually strongly advocating with many of my clients to use the patent office instead of court, and that's a little weird because I'm a court lawyer, but I do it because if you go back to the patent office, whether it be through CBM or IPR, the hurdle is lower. So the burden at the patent office of invalidating the patent is presumption, which is the 51% bar. If I go into court and try to invalidate a patent, the burden is clear and convincing, which I got to tell you, juries don't understand the difference between clear and convincing and beyond a reasonable doubt. They really don't. You can tell them all you want that it's 75% or it's not that high. They're still looking for the law and order sign in the background and, you know, oh my God, I had a question, so I'm not going to invalidate. Similarly, we're finding that at the patent office is far more willing to consider 103, to consider challenges that are combinations. In fact, in the very first IPR that invalidated a patent, it was a 4-item combo that actually worked. And 4-item combo. I would never put a 4-item combo in front of a jury. They would laugh at me. Of course it's not obvious if I have to go find 4 different, you know, pieces of art. So I actually am advising clients to use the patent office, although they're afraid. And they're afraid because they don't like going back into court without the balance or the baby split of, all right, your patent's valid but not infringed. So I think it's interesting, but I do find that it's becoming an incredibly valuable tool for us.
Absolutely, and I think it's important to recognize that a lot of the increase in patent troll litigation has really been against smaller defendants and non-tech defendants. And you know, this wasn't the case 5 years ago. 5 years ago, it was the lottery ticket model, and I'll go for the big tech company and hope to get $500 million. Now, the business model, the growth in the business model is really about extracting litigation costs from defendants that can't fight back. The only chance for those kinds of defendants to fight back sometimes may be a faster, cheaper procedure in the patent office. And I think it's good public policy to want those fights. I will say it's always a difficult strategy decision for defendants on whether to go to the patent office or court. I would say because of the estoppel, because of the high bar for getting into the patent office proceeding, has to be more likely than not, for instance, if the patent's invalid. Our sense is that defendants are really taking the worst patents to the patent office, the ones they feel that they can get rid of faster and cheaper there, and I think as innovation policy, that's a good thing. Going back to my original concern, I'm less concerned about separating court from the patent office and having those 2 tracks than separating out some of the validity criteria from others and not allowing the patent office to look at all of them. And this RIM case really shows, I think, that, you know, the AIA did some good things, but there's still a ways to go to really make that patent office procedure the best kind of procedure for innovation policy.
So I would be, if the answer is this turns out to be a workable and cheap mechanism, I think that's great. I do want to flag a couple of cautionary concerns, though. One is, Suzanne says faster and cheaper. I will sign on to cheaper. I'm not signing on to faster. If you take one of these procedures to the patent office and you invalidate the patent, well, then there's an opportunity to appeal internally in the patent office. The appeal backlog in the patent office board is now 25,000 cases, and they're sitting around for a couple of years. Once that's done, you get to appeal to the Federal Circuit. So it's probably going to take you until you're all done for sure. I'm going to guess kind of 4 to 5 years. During that time, the question is what happens to the infringement lawsuit? Right? So the question is the district judge going to stay the infringement lawsuit pending this internal patent office proceeding? If not, we may end up with a situation like the situation we've got in Germany. Germany has a split where the courts consider infringement and the patent validity questions get referred to the European Patent Office or the German Patent Office technical boards. The courts are quite quick. They're making their decisions in 6 to 9 months. The Patent Office is quite slow. They're taking 3 or 4 years. And the result is that when I get sued in Germany, I get enjoined in 9 months, and then 3 years later it turns out the patent that I was enjoined on is invalid. But I've still been enjoined from selling this product for a couple of years, right? So there's a risk, I think, that unless courts are willing to stay the litigation proceedings pending these determinations, the invalidity determination is going to be a kind of afterthought.
So far they have been. It's been about 70, the last statistics I saw were between 76 and 79% of motions to stay pending IPR have been granted.
I think it's important further reform is to make that rule more consistent and more uniform, because we still have this situation where we've got race conditions exist. If I make a logic circuit that the answer I get depends on whether some gates flip before other gates flop, that's a really bad logic circuit.
Yep.
And you've got a race. When we had the race condition a long time ago in the RIM versus NTP case. But there's a race condition in the SAP case, and there's a race condition with a lot of the Vernetics patents that are being re-examined. And, coming up with a consistent answer. First of all, I think in order to always have a stay, you've got to make the patent office procedure faster.
Yes.
You've got to get the patent office the resources to get through these things quickly. But I think there needs to be some kind of an answer to where we don't have these race conditions popping up, because it just makes the whole system look illegitimate.
We need to be careful in distinguishing between the procedures that were set up by the American Invents Act, which have an 18-month statutory deadline for the PTO getting through it, and so far they've met it, and they really need our support and resources.
So far they've met it, because it's only been 18 months since they filed any, right?
And the old re-exam.
Only 20 that are done, so
the old re-exam. But we all need to be supportive of the Patent Office so that they can make that goal, because the faster is important to avoid these problems.
So, Suzanne, you brought up another point of why the CBM and IPRs could be very useful is because of the cost. And because sometimes, especially smaller defendants, and not just smaller, sometimes the bigger defendants who have been hit by 50, 60, 90 litigations at any given moment.
100.
Exactly. Finally see themselves as saying, you know what, I myself don't have the resources to have all of my engineers in depositions all of the time, and it may just be better to settle this for a small amount or go to to CBM or IPR. One of the other things that I think reform-wise that a lot of people have been noticing and seeing, and I want us to talk about, is damages reform. And the idea that the Federal Circuit is handing out decisions that are helping courts kind of ratchet down, a prune back, I think was your other phrase, what the damage award could be, and really taking it to what was actually added as opposed to the whole computer that has all of this software on it. So what are you guys seeing vis-a-vis that? Like, Suzanne, what is your experience on the damages portion of it?
Not a great week to ask someone from Google that question. Our latest experience on Monday was the jury split the difference. The Simple Air asked for $160 million. We suggested 4 or 6 or something, and they came back with 90. We still don't have, in my view, good economic theories about how to deal with the situation in which products are covered by 10,000 patents, and that reality does not really come through in litigation, where you're still focused on one patent, and we don't have a good way to deal with the problem I started out by describing, which is, what this maybe really is we face these patents. A patent lawyer wrote the patent, never did any programming. It's now being stretched in some weird way to cover, in our case, it might be placing an targeted ad next to a search result. That basic kind of concept is covered. Well, yeah, so 1% of revenue sounds reasonable because that's what Google does, right? but really there was no technological contribution coming out of that patent. There's a huge amount of technology and what happens there, a huge amount of infrastructure and investment, and those sorts of broad non-technical patents can be extremely overvalued in this situation. And so there's been some improvement because there were so many problems. There's a really, really long way to go, and I always like to encourage any economists to tackle this area.
So I think it's definitely the case that we have made strides in the last 5 years in the sophistication with which courts approach this issue. Look, bear in mind, right, we started from a base at which the single most common theory of damages was the so-called 25% rule of thumb, which is to say we take the defendant's profits and we divide by 4 and we give that amount to the plaintiff regardless of what the patent actually was. And we had economic experts, right, whose qualification I think was they could divide by 4, right? And therefore they got up in the stand and they, built a model in which they said, here are the profits, and I divided by 4. Federal Circuit has quite clearly correctly thrown that out. We've required more and more methodological sophistication, but I do think we're running up against not only the substantive problem that Suzanne identifies, right, which is it's actually really hard to get across how many other patent owners there are out there, much less how many other technical contributions the company who's a defendant made, right? Actually building the thing is at least as important as coming up with the idea in many of these technologies. We run into the problem that at the end of the day, we hand this all to the jury, and juries are not really good at very small percentages, right? That's why people buy lottery tickets. They don't. The right number might well be 0.0003% of revenue, and to an economist, that's equivalent to 2% of a really tiny piece that's sold for a few cents. But to a jury, it's not equivalent. Those numbers don't end up being the same. We also were running into a practical problem, right, which is district judges don't like doing all of this on Daubert, right? What we've been telling them is it's your burden, not at summary judgment, because we're not excluding all damages, but sort of pre-trial in a Daubert hearing to wade through the economic testimony, to figure out what makes sense and what doesn't, and narrow and limit things so that the appropriate evidence gets before the jury. I sat on in a conference with 6 district judges in LA on Tuesday, in which they said, oh yeah, we don't, I have a heavy bias, a heavy presumption against a Daubert ruling. We think it's for extraordinary circumstances. That comes out of the idea that the point of Daubert is exclude junk science, right, from other areas where it probably should be rare. So maybe we shouldn't be calling it a Daubert hearing. Maybe we should be calling it something different. But district judges are, I think, reluctant to engage in the kinds of analysis they need to engage in to whittle damages theories for both plaintiffs and defendants down to reasonable ones. Some judges, Sue Robinson in the District of Delaware, just said, oh, I don't do Daubert hearings. Yeah. My jaw dropped when I heard that, because I always thought that, if you had a lawful motion that you presented before a district judge, they had an obligation to at least decide it, even if they were going to be hostile to it as a general matter. But, some of the judges look at this and they say, I'm too busy, this is pretrial stuff, and it's too complicated, and I'm just not going to deal with it.
It's interesting you raise the idea of not calling it Daubert, and I'm trying to figure out what else I should title it when I file my motions, but I agree with you, because I think a lot of district court judges have looked at it and said, well, he's a scientist, he has a credential, so I can't Daubert him, instead of he's not applying the right test. And that's really what this is all coming down to, is what is the test that we're going to be applying? Is it an entire market value rule, which is, I think, goes to Suzanne's point of, wait a minute, you can't get a portion of my entire market because you only contributed this tiny, tiny, tiny thing. Lee, what do you?
Well, I was just going to mention, I think an underutilized concept, and it's in the law, is how much does it cost me not to infringe, and the benefit of having a design around and showing that the cost of the design around is small. I mean, that I really think should provide a roof on a ceiling on the damages, because how much does it cost me to just avoid doing it? I mean, that's...
The fascinating thing about that, just so you know, it's perfect and it works well, but juries say, well, then why didn't you just do it? Why didn't you just do it if it was so easy? Why are we sitting here? You infringed. It must not have been as easy as you said it was, and so the damages can't be as small as you say they are. And it's unfortunate because what you're doing is you're saying to large companies, you have to switch even before you're found to have actually infringed.
Well, I think the thing is, the company may not know about the patent. That point needs to be made. And the company thought the patent was invalid. I mean, there's no reason to switch until
I'm just telling you what juries do when they say that.
Yeah, and it's almost a perfect circle, isn't it, to get us back to the start of our conversation about the unpredictability in the system, the difficulty in... and we should all be a little more upset about this than we are, that we can't read a patent and really know what the boundaries of it are. That's a failure of the system. And so when, I say, when a company's considering a design around and you're in the middle of a minefield and I'll design around the patent in front of me in litigation, and then are you on some other patent that you don't know about anyway, and you don't really know how far to step to the right to take to get out of the patent in front of you until the court construes it anyway. And I know you can't really convey all that to a jury, but that's the reality.
Three quick points here. One is, part of the problem is people often say, oh, it's easy to design around when in fact it isn't. So the defendants bear some of the burden for having sort of made arguments that they can't follow through on. Right. Second point is, I think we could solve much of that problem and some of this litigation problem if we were to systematically bifurcate damages in trials. One of the difficulties we have is that you can't actually put on very much evidence as a defendant in a patent trial about damages, because if you do, all the jury research literature says you've essentially going to be perceived as conceding the liability side, and we ought to actually have a separate trial of damages. After the Bosch pylon case, I think you might be able to have a trial on liability, take liability up to appeal, and then do damages later. Some district judges are talking about doing that. Final point as we circle back to sort of why can't I figure out what these patents are, it is definitely right that the problem in software is there is no way, for me to read all of the patents that could plausibly apply to me. Christina Mulligan and Tim Lee did a lovely study in which they took the number of software patents and the number of software companies, and they said, what if each software company paid a lawyer to spend just 10 minutes looking at each patent that could conceivably be asserted against them? And the answer was we would need 2 million lawyers working full-time to read the patents. But even if we hired those 2 million lawyers and had them full-time reading the patents, they're still not going to be able to figure out whether or not they infringe. That problem may change this year. The Supreme Court has a case, Nautilus versus Biosig, on indefiniteness. And the current Federal Circuit standard for indefiniteness is very lax. The test is the claim language insolubly ambiguous. I don't think that's going to be the test come June when the Supreme Court decides Nautilus versus Biosig. I don't know what it's going to be, but it might well be that the world is going to move back towards something closer to a standard of I ought to be able to read this patent and have some sense of whether or not I'm infringing it.
So I wanted to open it up to questions for everybody here, because we've been yammering quite a bit amongst ourselves with the things that we find frustrating and that we find interesting. But we want to know what you guys find interesting or frustrating about software patents and the needs for reform.
And please come to the microphones because we are recording.
Yes.
I guess I'm fastest. So, Mark, I've actually been following what you've been writing about the functional claiming approach for a while, and I was initially very, very enthusiastic about it, and I've become less.
Thanks. Next question.
I've become less so. I mean, mainly because what it seems to me is we've got a moving target. Right, you've got Federal Circuit case law that is moving away steadily from a true requirement of clear linking into if an expert looks at it and says it must be there, well, it doesn't matter that there's no actual explicit link. If that's the case law has gotten bizarre and is eating its own tail. I don't know that we're really gaining any benefit by putting us into a 112F situation versus where we are right now.
Well, so I mean, I think we get substantial benefit. If what you want is abolish software patents or win all of your cases as a defendant, it doesn't give you that. But I don't think it should give you that, right? It is by no means a panacea, right, for defendants, and it's by no means a kind of a perfect solution in the sense that it tells us exactly what the scope of claims is, right? But what it does, I think, is it prevents the worst set of the litigation in software patents, right, which are the people who developed some technology that doesn't look at all like the defendant's technology, but who can use a very generic claim language to say my patent now covers these claims, and that. Right, if the goal is invalidate these things on indefiniteness because I think there's no algorithm, the fact that there's less of a linking requirement may make that harder, right? But if the goal is to say narrow the claim, have it valid but narrower, and to say, look, I'm doing something that works in a completely different way, that's where I think it's useful.
I want to say, though, because I do like Mark's idea a lot. I talked earlier about the need to clarify what goes into the 112F bucket. We didn't get to. There needs to be clarification about what's a sufficient algorithm and whether there's an algorithm there. And there are two lines of case law, and one line says real clearly, this is about having clear boundaries on your claim. This is not enablement. Skill in the art, and the fact that some programmer could have programmed this function isn't what this is about. And I think that's the right way to go. This is about claim clarity. There is another line of cases, and there was recently the L-Commerce case, that wants to look at the skill in the art and say, yeah, a programmer could have programmed that function, so it's okay. And that's a problem, and we're going to need to fix it.
Next.
So I wanted to explore further the Lemley-Van Pelt debate on Section 112F examination. Suppose the Patent Office adopted the following procedure. Let the examiners, if they wanted to, reject a claim based upon a very broad reading of just its function and lots of broad prior art that would cover that, and force the applicant, if the applicant wanted to say, no, my claim's much more limited than that under Section 112F, and the broad prior art doesn't work. You have to find specific prior art that's equivalent to my structure.
So I think that gives you a better prosecution history.
Yeah,
the courts are somewhat reluctant to rule from prosecution history, but this sounds like a pretty clear one.
Well, that would come much closer to an actual disclaimer that they're looking for, because you're saying, I wasn't this broad thing, I'm this narrow thing. Right. That would work well for almost everybody.
So I think the interesting question is what happens when the applicant says the opposite, right? So when the applicant says, yeah, you know what, I don't think there's any. I don't think this is a means plus function claim, even though we don't actually see any structure there. I think Suzanne made the point earlier, which is exactly right, that this is not a decision we should let the applicant control. Right? The statute says you've either got structure in the claim or it gets treated under Section 112F. So the right response, if the applicant says, no, I want my claim to cover the entire function and not have structure, is too bad. You can have this claim interpreted under 112F, or you can have it thrown out, but you can't have both.
Well, so the concern So the concern I have, Mark, with what you just said is that the applicant disagrees, and then there is a mysterious examiner interview, and the claims are allowed with the prior art does not show X, and you're not left with a clear admission by the applicant that 112F applies.
Unrecorded examiner interviews are a tool of the devil, and they should be abolished, but that's an entirely separate panel discussion.
I think we would make clear is if the applicant does say, look, I don't think this is 112 paragraph 6, I think it should be broadly interpreted, the examiner should then be able to reject just based on finding the function. Because the problem with the state you don't want to get into is if the examiner then is still limited in the rejection that he can make, and then the court turns around and says, no, it isn't 112 paragraph 6, because the Patent Office doesn't get to give a dispositive determination of 112 paragraph 6 or not. So you really want to, I like the concept you had that the examiner can initially reject, and then it's up to the applicant. If the applicant wants to say, examiner, you can't reject me based on just finding the function because it's more narrow, then fine. I think
as long as it's done not in an interview where we don't know what happened, I think that's absolutely great. But if it's in writing, then everybody will know what those claims cover and everybody will know how that works. The problem comes when it's in an interview and we don't know that that's what the meeting of the minds was.
Absolutely, which is why I still, even after having lost the argument with Mark earlier, would prefer that the Patent Office be able to reject just based on finding the function. I mean, I just don't think that there is a strong enough downside to that, given that the applicant can amend. And that would have actually solved the problem in the RIM case with this result where the board can't get to an answer. If they could just reject based on finding the function, they could have at least given RIM given an answer on 102 and 103.
Anybody else?
We had one, but he went away.
I know, he's come back.
Now he's coming
come
back.
back.
He's got tired of standing.
If I can return to the first question for just a moment. It seems to me that
A little closer to the mic.
the part of the problem with accepting Professor Lemley's proposal on functional claiming is that the determination of the corresponding structure, and specifically the algorithm there, is seriously problematic. What constitutes a sufficient algorithm? We sort of have a baseline in Blackboard and desire to learn, but it's hard to tell how specific the algorithm should be or how detailed, and at what level of generality it is sufficient to kind of make it specific enough and protect the general claiming, especially because as software evolves, the whole point of software is to allow essentially a functional statement to do all of the work.
I think that's exactly right. As Suzanne suggested, there are some cases in the Federal Circuit that are at least in tension with each other on this question. As a general matter, the majority of the Federal Circuit case law has been fairly rigorous in requiring kind of real algorithmic structure. So the Ibermeath case, for instance, says just giving me a list of variables without telling me what the numbers are going to be, right? So it doesn't count as an algorithm. But that's clearly something we're going to litigate. There's certainly going to be a dispute and uncertainty around it, but it's dispute and uncertainty are kind of somewhere around the right answer, which is, it seems to me, far better than saying, you know what, it's every possible thing, whether or not I've got an algorithm disclosed in the patent at all, which can't possibly be the right answer.
I think you're absolutely right that there is going to be that dispute, but the alternative is not to have the dispute, and they get anything that does that function. So
I'd rather have a little bit of clarity to be able to advise clients. At least there's a good idea that you're infringing or you're not, as opposed to, well, of course you are, but now I have to figure out if I can actually get rid of the claims.
Definitely an improvement.
Yeah. Thank you.
I have two questions, and more like issues or points I'd like you to address, and I'll try to frame them as questions. The first one being, you mentioned something about a lot of patents being issued. I've heard a rumor, I don't know if there was any truth to this, and maybe you could shed some light, but around the time of the dot-com boom and then the bust, there was an initiative by the PTO to push through and grant a lot more patents. And so during that time period, a lot more subpar, crappy patents were issued by the PTO, and a lot of those companies that got those patents, either went bankrupt, went belly up, or got acquired by somebody else. In many cases, those were, subject to fire sales, and now they're in the hands of patent trolls. And so the first question is there any validity to that rumor?
Well, I don't know that I can attribute intent. That is, I don't know, it was a deliberate policy, although it is worth noting that in the 1990s, the PTO's mission statement was, our mission is to help our customers get patents. which is, it seems to me, a pretty one-sided view of the role of an agency that is actually designed to distinguish between the good and the bad.
Yeah, they define customers as the patentee.
Right.
Patentee,
But the factual claims, I think, are right. For whatever reason, and it might be the way the PTO behaved, it might be the absence of good sources of prior art in the 1990s. I think we saw a higher grant rate in the software area in the 1990s, and I think a lot of the problematic patents come out of that era. It might also be that things like the internet were much earlier days, and so it was more open to claim I'm the first person to do X on the internet, and therefore I own all possible ways of doing X on the internet.
The bane of the patent office is the backlog, and this was especially, that's the one thing about their performance that everybody can measure and everybody can understand. You can draw a graph that says this is how long it now takes to get a patent. Isn't that terrible? And the reality in the late 90s, especially in early 2000s, because a lot of the money was diverted from the patent office and they didn't have enough examiners, that the only way to reduce the backlog, given that applicants are unlikely to give up, is to grant patents, all right? So that's, I think, what happened.
And you couple all of that with State Street in 1998, suddenly allowing the kinds of patents that we started this conversation, and those come flooding in. And it was in some ways a perfect storm to create what we're living with right now.
So I go ahead and wrap up what you said you had
my
2
second
points.
question. The second issue is on the issue of design arounds. Don't you think a jury would find a response by the defendants, find the following response credible? I'm a big tech company. I receive, 10 or 12 patent assertions every month. And if I had to ask my engineers to design around every single patent claim that comes my way, they would spend the majority of their time trying to design around everyone's patents rather than innovating and developing new technologies and new products. And therefore, I'm here today in court because I am entitled to my day in court. We've looked at the patents. We don't think we infringe. We've also seen, we've looked at prior art. We think the patents are invalid. And so with that premise, the reason we're in court today for this case is because, we're entitled to our day in court just like the plaintiffs say they're entitled to their day in court.
Here's how I spin that if I'm the plaintiff's lawyer. Defendant just told you that they ought to be excused from infringing our patent because look at all the other patents they also infringe. Is that the kind of company you want to reward, or do you want to reward me, the good old inventor? And there's some truth to that. I think one of the ways you can solve the design around problem and not incidentally distinguish between the people who really can do a design around cheaply and those who are bluffing is to say, you know what, all right, the patent is infringed and so we're not going to do anything for a month or 2 months. And if 2 months from now you've solved this problem and you've designed around successfully, well, you were right, and nothing happens, and that fact ought to go into the damages calculation, and it means there's no injunction. But if you can't do it, then of course the patent starts to look a lot more valuable. So we could stay injunctions for a limited period of time to allow for a design around. We probably, if we bifurcated damages, we probably could, I don't know that we could stay damages, but we could sort of delay the damages trial until after we know whether the design around really was that easy. And that fact probably ought to be the central fact in the design around trial. That might be a kind of step in getting that
Bifurcation is important because you've also got the problem if you design around, you sort of make yourself look like you think you infringe. So
the biggest problem is the jury, by the time you get to the issue of design around, the jury's already found that you're infringing, which means they're not really liking you all that much anyway. So then when you stand up and say, I didn't have to do it, they're not likely to believe you. And so it's a complex problem of all the facts overlaying each other.
Bifurcation is an important answer, solution to that.
So, I guess one follow-on question to that would be when you're, I think I agree, bifurcation is very important. A lot of judges don't exercise their discretion to bifurcate damages from liability. That, when you start presenting a damages case, start talking about damages, juries automatically think, well, if you're talking about damages, you're saying you could design around for $100,000, you probably infringe, and it's just an excuse.
Right. Well, I agree, and that's what happens. We want to get you guys out to your break so that you can have time to do emails and coffee and everything else, but I know that at least the panel will be up here for a little while if anyone wants to come up and talk to us. Thank you so much for your attention, and I think everything resumes at 10:30, is that right?
10:45?
10:45.
10:45.
So 10:45.
See you here at 10:45.
Thank you.